Well, good morning, friends. So let us discuss today INCOTERMs. That means International Contracts of Sale. INCOTERMs means International Contracts of Sale. So in considering a proposal for cargo insurance, one starts with the sales contract. The terms of sales dictate immediately which of the parties to the contract is to be responsible for insurance. In an international sale, the seller and the buyer both have obligations to fulfill, in return for which the buyer obtains the goods and the seller is paid the prices. Now, the purpose of an international sale is to transfer goods from the seller to the buyer. For normal sales within the country, risk in the goods moves from the seller to the buyer at the same time as the property is transferred. This means that the seller is responsible for any loss or damage suffered by the goods until their ownership passes to the buyer, and that after transfer the buyer is responsible. So this applies to normal sales within the country but not to export sales. So the contracts of international sale, transfer of risk and transfer of property are separated. In contracts of international sale, transfer of risk and transfer of property are separated. So in the more common forms of international sale, such as free on board, C&F and CIF, the risk in goods passes to the buyer once such goods have passed in ship's rail at the port of shipment. But the property in the goods will not pass until the buyer has taken up the documents in the country of destination and accepted the goods. So there are variations such as sales X works, where the buyers will bear all the risk from the factory gate, and the opposite X pay, means duty paid, named port, where the seller carries all the risks until the goods are at the disposal of the buyer in the country of destination. However, the first three named, namely FOB, C&F and CIF, are those most frequently encountered. So what is this FOB? FOB means free on board. Under FOB contracts, the seller undertakes to deliver the goods over the ship's rail, at which points the risk passes from the seller to the buyer. So the seller's responsibility is to pay all expenses until this point. The buyer is responsible for freight and other subsequent charges. The buyer is also responsible for insurance from the time he assumes the risk. That is, once the goods pass the ship's rail, the seller in his own interest, therefore, must arrange insurance from his own premises to the ship's rail at the port of shipment. Another one is C&F, means cost and freight. So under C&F sales contract, responsibility to arrange insurance is on the buyer. The seller has to give notice of shipment to the buyer to enable the latter to arrange insurance. So the seller undertakes to fix the shipping space, deliver the goods on board and pay the ocean freight. So the risk passes to the buyer on shipment. Until shipment, however, the risk and property in the goods remain with the shipper, that is the seller, and as in the FOB contract, the seller will need to protect this interest by insuring the goods from the warehouse till they are loaded on the overseas vessel. The third one is CIF, cost, insurance and freight. So on CIF sales basis, the seller is responsible for insurance from his own premises to that of the buyers at the destination point. So the policy is truly warehouse to warehouse. The policy is taken out in the seller's name, and any claim will be negotiated by the buyer, generally through a claim settling agent at the destination place in his own country. It is important to note that under CIF contract, the insurance arranged by the seller covers the goods from the seller's warehouse to the buyer's warehouse. And the same policy protects the interest of both the seller as well as buyer when the interest in the goods insured passes from the seller to the buyer overseas. So under CIF terms of sale, the seller must tender all the relevant documents to the buyer, his agent, or his bank. So the relevant documents are the invoices, invoice, bill of lading, and policy of cargo insurance. So the buyer must accept the documents and pay the price. He may of course refuse to accept the documents if they are not in accordance with the contract, though they may be retendered to the seller in a satisfactory condition within the contract period. So property passes when the documents are transferred. Risk, however, is deemed to have passed at the moment of shipment. If anything has happened to the goods during the voyage, the buyer will be protected, as he will take over the insurance policy when the documents are transferred. So it should be noted that the transfer of documents is in law the transfer of the goods. So even if the goods are lost, the sale can be performed by the transfer of the documents. So the CIF contract has been judicially described as contract for sale of goods performed by the sale of documents. CIF contract has been judicially described as contract for the sale of goods performed by the sale of documents. So this is an apt description. Now following arrangements in the tabular forms summarize the foregoing discussion sometimes on the series sale contract. Say for example, sale contract is FOB. Who pays the freight? Buyer. Who arranges insurance? Buyer. Risk shift from seller to buyer when cargo is placed. So on board the vessel. So this is FOB contract where the freight is paid by the buyer or insurance is arranged by the buyers. So on board the vessel. Now in C&F, who pays the freight? Seller. Who arranges insurance? Buyer. And this shift from the seller to buyer when cargo is placed means on board the vessel. And in CIF, who pays the freight? Seller. Who arranges the insurance? Seller. And this shift on board the vessel. So the documentary credit is also important in this case. An important importer placing an order for goods can send payment in advance, that is cash with order, or he may ask the exporter to draw on him the documents attached, either at site at so many days, or he may open a documentary credit in favor of the exporter. In most cases, the first course will not be attractive, as this is a form of the advance payment. The second course will not be possible unless the importer is well known to the exporter and relations between them are of such long standing that a high degree of mutual trust exists. So the importer will therefore in most cases take advantage of the facilities provided by a documentary credit. In practice, the exporter may very well specify that form of payment. So under this arrangement, the buyer requests his bank to establish a credit in favor of the seller. The importer will approach his banker and indicate the details of the credit required. If these proposals are accepted by the bankers, they will be incorporated in a special form of instructions or letter of undertaking representing the contract between the importer and the banker. So this form or letter will specify the rights and obligations of each party. In most cases, the banks will take the form. They will take from his customer a deposit or margin, having agreed with the customer the terms of the credit and the margin and commission payable. So the banker will issue his letter of credit. Thus, a letter of credit is a financial guarantee or an undertaking by a bank on behalf of the importer that payment will be made to the exporter subject to conditions contained in the letter of credit. So normally this will be an irrevocable letter of credit, which is an absolute undertaking to honor drafts in accordance with its terms provided the condition of the letter of credit are fully observed. So the issuing banker, that is the buyer's bank, gives the beneficiary, that is the exporter, a direct undertaking to honor such credit. Such a credit cannot be recalled before expiry without the consent of the beneficiaries. So in passing the credit to the beneficiary, the issuing bank will usually make use of correspondent bank established in the country of the beneficiary. In some instances, the credit is required to be confirmed by that correspondent bank, and its confirmation means that the beneficiary obtains from a bank in his own country the irrevocable undertaking to pay rather than having only the promise of a bank in a foreign country. So in other words, the buyer's bank, that is the issuing bank, undertakes or authorizes its correspondent bank in the exporter's country to pay the exporter a sum of money, normally the invoice price of the goods, against presentation of specified shipping documents. A documentary credit is a mandatory contract and is completely independent of the sales contract. It is concerned only with the documents and not with the goods to which the documents refer. Liability for payment now rests with the issuing bank and not the buyer. Such credits are usually irrevocable, which means that they cannot be withdrawn, cancelled, or amended without the agreement of the beneficiary, that is exporter, and all other parties. So it is possible to issue revocable credit, but these are not nowadays common. So the exporter can thus rely on payment being made as soon as he has shipped the goods and produce the necessary documents. So the security provided by an irrevocable credit may be further enhanced if the bank in the exporter's country, called the negotiating or advising bank, is required by the issuing bank to add its confirmation. So the exporter is then said to have a confirmed irrevocable credit, and he need look no further than his own local bank for payment. If a credit is not confirmed, liability for payment rests with the issuing bank approval. Thank you very much.